In life, we conclude contracts on a daily basis. I'm sure it is of interest for you to find out what contractual capacity is. Welcome to our discussion on contractual capacity, where we try to answer a few questions, with the first question being, what is contractual capacity? As well as trying to identify the factors that determine contractual capacity. But to begin, let us look at a few scenarios. Imagine Tabo, a 6-year-old minor who wants to receive a house that's being given unto him in a will. Does he have the competence to receive that house? What about Togo, a 13-year-old girl who wishes to terminate her pregnancy or to undergo an HIV test? And then what of Keith, a 27-year-old married man who's married in community of property, and he wants to sell his family house? Imagine also we have Jack, a 24-year-old drug addict who has donated her immovable property to a friend. In this particular case, we are trying to find out whether the donation is valid, whether he has the capacity to do that. What about Kamkhelo, a 17-year-old who wants to apply for a learner driver's license? Does he have the capacity to do that? What of Temba, who is married to Susan, who got married to Susan in 1978 and was entitled to marital power over his wife, and Susan entered into a contract for the purchase of a house in 1984. Then Susan went on to default in payments, and now the bank wants to attach the family home in which they are staying. And then we've got Mavis, a 43-year-old highly generous woman who donates up to the last cent of her salary every month, to the point of becoming destitute or semi-destitute. Last but not least, let's look at Adams, a 56-year-old male whose debts outstrip his estate, such that he is unable to service them as they fall due, and then he is declared insolvent. Now, these are some of the scenarios that summarize the main issues we look at when we are dealing with capacity to act. Capacity to act is linked to legal subjectivity. One question that is always important to answer in law is, who is a legal subject? Or rather, who is a legal person? Who is a person in terms of the law? You will discover that this is an aspect of the law of persons. In order to fully understand who is a legal subject and the matter of legal subjectivity, you need to visit or rather study the law of persons as a component of the study of law. Now, there are two distinguishable classes of legal subjects. We have natural human beings who are called natural persons, and we have juristic persons who happen to be entities which acquire the status of legal subjectivity through incorporation or constitution by natural persons. We've got quite a number of these types of juristic persons, but what we may just say is that a juristic person is a legal fiction created by humans who also assign some competencies to this legal person. When it comes to juristic persons, we have got entities which have been given legal personality by the General Enabling Act of Parliament, For instance, a company operates in terms of the Companies Act. So it derives its status from the Enabling Act, which is the Companies Act. We have got some which are incorporated, or rather created, in terms of acts of parliament, such as we have universities, we have broadcasting corporations, or in the case of South Africa, you will have ESCOM, the Electricity Supply Commission. And then we have voluntary associations or clubs, which also do acquire the status of legal persons, so to speak. And then we need to take note that a legal subject is a bearer of rights, duties, and capabilities. That's what defines a legal subject. Now, the issue of legal capacity is quite a broad issue. Legal capacity means the capacity to be a bearer of rights and obligations. So, as we have seen, natural persons as well as juristic persons are bearers of rights and obligations. So that makes, or rather qualifies them to be called legal subjects, and they have legal capacity. But looking at legal capacity, it constitutes three competencies, three very important competencies. First, there is the capacity to have rights and duties, and then the capacity to perform juristic acts, and as well as the capacity to sue and be sued as a party in a lawsuit, what is sometimes called locus standi in judicio. Right. Looking at contractual capacity, it is an element of legal capacity because it refers to the capacity to perform juristic acts. As we will see later on in the discussion, trying to identify or seeking to identify the factors that determine this capacity to perform juristic acts. While it is true that every legal subject has legal capacity, it is equally true that not every legal subject has capacity to act. You see, that's a very important point to note. Every legal subject has legal capacity, but not every legal subject has capacity to act. Take note of a distinction between legal capacity, capacity to act, as well as capacity to be held accountable for civil and criminal wrongs. The last being the capacity to incur liability for crimes and delicts. So we're basically saying that there is what is called capacity to act. Capacity to act being that capacity to perform valid juristic acts. And then so we are asking ourselves the questions: who has the capacity to perform valid juristic acts? Who has that competence? And particularly in the area of the law of contract, this is the most important of the three. Who has that capability or competence to perform valid juristic acts? And as we said earlier on, this is an aspect of legal capacity. Whilst the issue of civil or criminal liability is a different issue altogether, which tends to be the main focus in matters of criminal law and civil wrongs, such as delicts of various kinds. The question then is, what is capacity to perform juristic acts? We have tried an introductory explanation there, but maybe we need to go a little further in trying to unpack the details of what legal capacity is. It is capacity to perform valid juristic acts, for example, to participate in legal dealings and to conclude valid contracts. Take note of the fact that only natural persons have capacity to act. That is, natural persons conclude contracts on behalf of juristic acts. A company is not endowed with capacity to act, but its agents, who could be the incorporators or the directors or whoever is empowered in terms of the internal documents of the company, is the one who's appointed to act on behalf of the company, and it is natural persons who do so. Again, we are noting that natural persons' capacity to act may be limited by law. We will look at that one as we progress later on in the discussion. And it is very important to remind one another that capacity to declare a will or make a valid testamentary disposition is also an aspect of that capacity to act. The ability to judge the rights and consequences flowing from a will is very important. And sometimes people get to be declared as prodigals following irresponsible behavior, which means that would cause a serious deprivation or limitation rather of their capacity to act. A person may be declared insolvent due to voluntary surrender or compulsory sequestration. You remember our scenarios that we began with. A person whose debts or liabilities outstrip his capacity to pay, he can be declared insolvent in terms of the Insolvency Act, and then they'll have their estate falling under the administration of the master of the High Court, and then an appointment of a trustee to make sure that there is a fair distribution of the assets among the creditors of the insolvent. Take note also of the juristic person's ability to enjoy legal capacity, or sometimes as juristic persons such as companies and close corporations, when they when there are problems, or rather when one of the agents goes and acts on behalf of the company and then does things that are outside the memorandum of association or articles of association of that company, it may cause an invalidity of the contract arising from that. But a lot has changed in the area of company law, particularly when we look at the relevance nowadays of the principle of atra virus, which has not been as popular as it used to be. Maybe these are some of the issues that are just of interest to those who have an interest in companies law. Now, talking about natural persons who happen to be the people and the natural persons and the people endowed with that capacity to act. Having said that, juristic persons don't have the capacity, a few questions arise. We are trying to understand the basis for contractual capacity. In order for us to say so and so has intellectual capacity, what comes into mind? What is important? First, in fact, there are two factors to look at, or two components, two elements to look at. There is what is called the intellectus as well as the judicium. We are talking here about the intelligence or the intellectual ability to understand the contents of the proposed contract, and then judicium refers to that discretion or that ability to make a valid judgment of whether the contract that one is undertaking is of benefit or not, the consequences, so to speak. If one fully understands and appreciates the consequences of the contract that they are entering, then we may say that they have discretion in respect of that. So the main question will always be, does one possess a level of intellectual and emotional development enabling her or him to form and declare valid will and appreciate its consequences? So age is a very important determinant of intellectual and emotional development, and there are 3 age bands in common law, because there have been some changes, some statutory changes in recent years, but in terms of common law, there were 3 age bands for natural persons. We would have the 0 to 7 years of age, called an infant or an infant. That one was considered to be bereft of any ability to appreciate, but I'm sure we'll as we go down, we'll look at some of these issues. So the 0 to 7 years and infants, then the 7 to 21 as a pupillee, and then 21 years and above being the adults. But now recent changes in South African law have altered the second band, that is the 0 to 21. It's now been changed from the 7 to 21 is now the 7 to 18 age band. Then what used to be 21 and over is now 18 years and over. The Children's Act 38 of 2005 repealed the Age of Majority Act 57 of 1972. It is the one that adjusted the second, that is the second age band, the 7 to 21. It brought it to 18, so that it now runs at 7 to 18. This new act, like we have said, it changed the band, and it came into force on the 1st of July in South Africa in 2007. It's a very significant piece of the law if you can have access to it, and just familiarize yourself with some of these fundamental changes that it introduced. Now looking at minority, who is a minor? A minor is a child, and the child is a person below the age of 18. Minors have limited capacity to act, and in some cases they completely lack that capacity to act, depending on their age. Remember, we've spoken about the 0 to 7 year age band. So the 0 to 7 years have insufficient powers to understand and make proper judgment of contracts. They have no capacity to act. They cannot even conclude any contracts in terms of which she acquires rights and does not incur obligations. So in other words, a 0 to 7 is not even competent to receive a donation. You see, as it is, in terms of a donation, he does not have to incur any loss or any cost or any liability, but still the law considers that the 0 to 7 year band is not sufficiently developed, doesn't have the intellectus or the judgment to be able to decide whether to receive a donation or not. Now, a child of 7 years and over, that just means up to 18, can exercise independent intellectual discretion, but lacks that sound judgment on contractual matters. So these people have limited capacity to act. They conclude agreements with the assistance of majors or the assistance of their guardians, their parents or adults. Meanwhile, a major or an adult is somebody who is above the age of 18. In the past, it used to be 21, but now it's 18. A person reaches majority at the attainment of that age, unless limited by other factors such as mental deficiency. A child below 18 can, with the assistance of a minor or parent or other duly authorized major, bring a matter to court. That doesn't mean that the child has become a major, but the law enables them, it permits them to bring matters for consideration by the court. And marriage brings an end to minority if, for instance, a child gets married before the age of 18 and then he divorces or becomes widowed or something like that happens, and the termination of the marriage does not lead to a resumption of minority. That person will continue like to be a major as if he or she had reached the age of 18. I'm sure you might be asking yourself questions how it is possible for a child of less than 18 to get married. Yes, in exceptional circumstances, the Minister of Home Affairs may, on the application of an interested party, permit, but that would be very rare, very exceptional circumstances permitting that kind of a marriage for minors. Let's look at the statutory law and how it regulates issues of minority or minors in South Africa. We mentioned earlier on that the Children's Act 38 of 2005 is very, very significant in respect of regulating the conduct of minors. Remember, the guardian of a child may assist the child or represent the child in administrative, contractual, as well as other legal matters, and parents have equal rights of guardianship over children born in the marriage. Consent of both parents is required in respect of certain matters when one parent has legal guardianship, e.g., a child's marriage, an application for a passport, departure from the Republic of South Africa, or alienation and encumbrance of some immovable property of a certain threshold, as the minister may determine from time to time how much the value of the property for which such consent is not applicable. Well, the question is, how do parents exercise that parental assistance or the guardian's assistance? How does it show? How does it manifest? The parents may assent and be present at the conclusion of a contract to validate the contract and to show their consent for the minor's involvement in the contract. Or they may give prior authorization, and in some cases they may ratify an act that has already, a contract that has already come into effect. Now, the process of ratification also varies. It does not always constitute, or rather, it doesn't always constitute an express, statement by a guardian to say, yes, I authorize my child or the minor to participate. But sometimes it may be tacit. For instance, imagine that a certain minor has entered into a contract, and then later on their guardian or parent helps that child to enforce the terms of that contract. Under such circumstances, we then say, without expressly declaring the parent's acceptance or validation of the contract, by merely assisting that child, it's a tacit or a hidden way, a not so express way of saying, yes, I consent to the child is being bound by this contract. An assisted minor, an assisted contract binds the minor, and it becomes enforceable by and against the minor. Take note that the guardian does not acquire rights and does not incur liabilities on that contract. So even if a guardian assists a child or a minor to conclude a contract, and later on something goes wrong, and then the minor starts maybe relying on the fact that he or she was a minor when the contract was concluded, the other party to the contract does not have recourse to, maybe suing the guardian, because the guardian only consents to the minor incurring a contract, or rather concluding a contract. But that guardian does not bind himself to the point of being a bearer of rights, duties, and obligations in respect of that contract. It is not involved with it. In some cases, the law dispenses with the parental consent. For instance, a guardian's assistance is not always sufficient for a valid contract by a minor. In some cases, in some transactions where a minor is involved, it may require the consent of the master of the High Court, who must authorize the alienation or mortgaging of immovable property belonging to the minor for a certain value as determined from time to time by the minister responsible for the act. For that, yes, the act here that we are talking about is the Administration of Estates Act. And in some instances, the consent of the High Court is required to authorize alienation and mortgaging of immovable property over 100,000 rands. I'm not sure if it still stands that. These are some of the thresholds and maximum limits that are changed from time to time. So you may have to check with the government gazette to establish exactly whether it still stands at that. Now, restrictions only apply to alienation and not acquisition of property. A tacit emancipation sometimes arises, a scenario of tacit emancipation. What do we mean by this? A minor may begin to act as a major, and then you find that the parents tacitly, without expressly making that declaration, they permit that child to act as if he were a minor, rather a major or an adult. Under such circumstances, it is then said that tacit emancipation has taken place. But this used to apply particularly during the period when the age of majority stood at 21, because then people between the ages of 18 and 21 could be tacitly emancipated. And so when a child is maybe left to operate, say, his own account or his own business, and the parents don't seem to be interfering with that child's business, so to speak, it may sometimes be interpreted as tacit emancipation of that child. He's been emancipated from the control of the parents and now acts as an adult. Now, there are certain contracts that may be concluded without consent in spite of the limited capacity of a minor. And then maybe the guardian may go on to ratify the contract after the fact. Or once the minor becomes an adult, say after attaining the age of 18, he may either repudiate the contract and declare that it does not uphold the contract because he concluded he was a minor, or by maybe acting in terms of that contract, continuing to pay installments if it is a hire purchase, property acquired by hire purchase, or take for instance a child who continues to use the property that was acquired. That is a form of ratification of that contract. What happens if a minor goes out and purchases goods such as food, or the kind of goods that may be classified as necessities? Under such circumstances, the contract may bind the child, or if that child is not bound in terms of the contract, he would still be bound for undue enrichment, and then the parent may be, in some cases, expected to settle whatever debt was incurred by that minor during the course of acquiring the necessities of life, such as food and clothing. And then, we have problems that arise when a minor who misrepresents fraudulently induces a major to conclude a contract with him. Such a minor may be held liable, but a controversy in law is whether he is being held liable on the basis of a contract or ex delicto, that is on the basis of a delict or that fraudulent misrepresentation. Because remember, the law as a policy issue, it would not be legally sound for a minor to turn himself or herself to an adult by fraudulently misrepresenting and bypassing the law. So it would be arguable that the minor who misrepresents himself as a major is held to the contract. In fact, is not held to the contract, but is held to the obligations on the basis of delict, not on the basis of a contract. Now, there are statutory exceptions to common law incapacities of minors. Think about the following. Within a year of attaining majority, a minor may apply to the High Court for the cancellation of a detrimental contract concluded during minority. That minor must prove that the contract was detrimental to him or her. An unassisted minor may conclude contracts in which he acquires rights without incurring obligations. For instance, receiving a donation or release from debt. Some statutes do confer capacity to minors. For instance, the Choice on Termination of Pregnancy Act 92 of 1996 allows a female minor to consent to termination of their pregnancy. On a similar note, in terms of the Road Traffic Act, a 17-year-old may apply for a driver's license and doesn't need the consent or validation by a parent or a guardian. And the minor may withdraw monies or deposit monies with a deposit account, a bank, a post office savings bank, or any other money institution accepting deposits. And a minor is also permitted. The law permits permits a minor to draw a valid will, and draw a testamentary disposition about their estates. There are certain statutes that confer capacity, as we have mentioned above. A child below 15 may not be given out in marriage for religious or social purposes without their consent, but the Minister of Home Affairs must and must consent in exceptional cases to the marriage of a child below the age of 18. As we have said before, these would be very special circumstances. What about the issue of medical treatment? We have already indicated that children can consent to medical treatment or operations on them. A child of 12 years or over who displays sufficient maturity and mental capacity to understand the benefits, risks, social and other implications of medical treatment, operation or otherwise, may, without parental consent, undergo that kind of an operation. Well, not an operation, but that kind of a treatment. And sections 129 to 134 of the protective, which are entitled protective measures relating to the health of children, they waive parental responsibility or approval for HIV tests for a child of 12 years or over who displays understanding of the risks, implications of the test. Now, children can access information on sexuality and reproductive health. Now, all these are we are talking about the Children's Act of 38 of 2005. This is all these sections that we are referring to here about HIV tests and so on. They are based on that act. Now, marriage affects a person's capacity to conclude a contract. But before we look at how, let's look at the types of marriage, of matrimonial marriage regimes rather. We are saying the patrimonial consequences emanating from the marriage have implications on capacity to act in respect of the joint estate. Until the abolition of marital power in terms of Matrimonial Property Act 88 of 1984, the husband exercised marital power over the wife, being head of the family, possessing power over her person and over her property. Marital regimes, there are two major marital regimes in South Africa. There's marriage in community of property as well as marriage out of community of property. Marital power was the kind of power that a man exercised over his wife. In other words, when a man and a woman got married, during those times, especially marriage out of community of property, the woman or the wife was subject to the marital power of the husband. The wife had limited capacity to act. She could not act in terms of contracting on anything which forms part of the joint estate. And contracts which were signed by a wife subject to marital power and not ratified by a husband were voidable. Such doesn't seem to be practical anymore. What is the effect of in-community of property regime on capacity to act? Separate estates are consolidated into one joint estate, and the rights and the duties and obligations binding on the joint estate become the common rights duties of both spouses. Contractual rights and duties are shared by the spouses. Consent of the other spouse is required if alienation of or encumbrance of immovable property and financial investments are concerned, and the spouse binds herself as surety. If a spouse wants to bind himself or herself as a surety for a debt, there is need for written consent by the other spouse. Or if one spouse wants to act as a purchaser of certain property transactions or tries to withdraw monies held in the name of the other spouse, there is need for consent under such circumstances. Now, the formal consent, there's formal consent which can take the form of a written consent as well as informal consent. But in each case, the other spouse, where it's necessary and required, must consent and validate the agreement. Now we are saying consent may be granted tacitly or expressly. It may be given before the contract is entered into, or ex post facto ratification may be sufficient in certain circumstances, whereby the spouse has already entered into that contract and then the other one ratifies it after the fact. Now, prior consent is required in respect of certain transactions, for instance, where there is disposal of maybe immovable property belonging to the joint estate, and then a contract lacking such a consent is not necessarily invalid, unless it is clear that the other party would not have reasonably known. In other words, when one spouse enters into a contract, the circumstances will determine whether it was valid or not valid. But otherwise, if the other party entering into the contract would not have known that the spouse lacked a capacity or lacked the consent of the other spouse, the contract would be valid somehow. Now, what's the effect of out-of-community of property regime on the capacity to act? The joint estate is excluded by means of a validly executed anti-neutral contract. What happens in the case of a marriage out of community of property is that before these spouses marry, before the two come together in that union, they must sign a properly executed anti-neutral contract with a notary or a competent officer of the court, where they state clearly how they are going to run their estates, who's going to be entitled to what assets, and how they are going to contribute to the common expenses of the household. So the anti-nuptial contract then serves as that basis for document, the basic document defining the property regime of that marriage, spelling out who is entitled to which assets and how assets are to be dealt with at any time when necessary. And these spouses are liable pro rata, that is to pro rata contributions as far as household necessities are concerned. In other words, each spouse will have to contribute to basic necessities of the household, such as the food expenses, rentals and bills, and so on and so forth. Now, if one spouse goes and incurs expenses which are, which can be considered household necessities, then the other spouse may also be bound to that kind of a debt. And we are saying spouses are liable to third parties for all debts incurred by either spouse for household necessities. Otherwise, if it is for luxuries, if the other spouse decides to go on holiday without the consent or approval of their life partner, such debts may not be honored by the spouse who was not involved in incurring them. There are many other factors that limit or restrict the capacity to act. One of them being mental deficiency. What do we mean by a mentally deficient person? A mentally deficient person is one who is incapable of understanding or appreciating the consequences of his or her conduct and to make rational decisions based on that understanding. I'm sure you remember what we said about intellectuals as well as judicium, that is understanding and discretion or judgment. So a mentally deficient person lacks both of those qualities, and therefore he or she lacks contractual capacity. Contracts concluded by a mentally deficient person are void whether they are reciprocal or only confer rights and no obligations to the mentally deficient. In other words, a mentally deficient person cannot even take part in receiving a donation. Doesn't have the capacity. He lacks that capacity. And but because there is a presumption of normalcy on everyone, it is assumed that everyone above the age of 18 is normal and has that capacity, contractual capacity. Unless a member of the family or an interested person applies to a court in terms of the Mental Health Care Act of 2002, and then following that application, a mentally deficient person may be declared incapable as lacking contractual capacity. Then a curator or somebody to manage his or her affairs is appointed by a competent court. Unless such is undertaken, a contract concluded by the person during the period, unless such measures are taken, it will always be assumed that the person is mentally sound. And now, another important point is that since a mentally deficient person may not be deficient all the time, there may be periods where he or she fully understands and appreciates what he or she is doing. Those are periods that we call lucid intervals, or those periods of normalcy. Contracts concluded during such periods of lucid interval or normalcy are imputed to the mentally deficient persons. In other words, he or she will be bound if she concluded those contracts during the period of that lucid interval. But if a declaration is made by a competent court of law, then capacity is restricted for that period of time. But remember that capacity is not terminated. Declaration of incapacity shifts burden of proof, since it creates a presumption of contractual incapacity. So in other words, all the other people dealing with the person may always assume that the person has capacity to act until it is demonstrated that he or she lacked that capacity. And that would be by showing maybe the court order where that declaration was made, as well as the relevant medical certificates from the mental health institution that would have certified that person as being incapable. Because some people abuse alcohol and drugs, it may also impair their capacity to act. Intoxication due to alcohol and drugs affects a person's ability to appreciate the nature and the effects as well as consequences of their actions. So such people may sometimes be incapable of controlling their actions or forming a valid will. A contract concluded by a person in such a state is void and unenforceable. But because capacity to act is not excluded by intoxication, if the person is still able to form a will, in some cases, in fact, or let me say, it will always be assumed that the person has the capacity, unless and until he or she sufficiently proves that she was under intoxication. Because remember, there is always a presumption that every person has capacity, which means anybody who alleges that they lack the capacity, they bear the burden to prove that they did indeed lack capacity. Otherwise, any adult is assumed to have capacity. Now, remember, we spoke about, in our scenarios, we spoke of a lady who always gives out the whole of her salary by month and becomes destitute in the course of the month. And we said that sometimes family may have to, or a member of the family may have to apply to the court to have that person declared a prodigal. Once that court order is issued on the application of a third person who's an interested party, there may then be an appointment of a curator who would manage the affairs of the prodigal. What are the grounds for declaration of someone as a prodigal? Inclination towards recklessness, irresponsible, extravagant use of money or financial resources, or failure to competently manage one's affairs. And what is the effect of the order? The order only limits the prodigal's capacity to act just the way it does the child, just the way a child has limited capacity. So the prodigal also has limited capacity, but not in respect of maybe every aspect of their life. It might only be in respect of some clearly defined aspects which may be stated in that court order. And then contracts concluded by the prodigal without the validation or the consent of the curator, they are actually voidable at the instance of the curator. But the curator may decide to ratify them if he thinks it is proper to do so. So we are saying the contracts are not void, but they are voidable. The prodigal retains capacity to act and to conclude contracts that are to her advantage. And the prodigal cannot conclude certain contracts without assistance of the curator. And then if the prodigal or the person shows improvement and change of maybe attitude and way of doing things, they may have later on the order being set aside by the court so that they resume their full capacity, their full legal capacity, or rather their full capacity to act on their own. Insolvency also does have the effect of diminishing one's capacity to act. But insolvency does not terminate capacity to act overall. It only restricts the capacity of the insolvent person to act in respect of the insolvent estate. Remember, when an estate is declared insolvent, the master takes over the estate and then the trustee administers that estate. So the insolvent has capacity to act in respect of all other areas of his or her life, except only acting in terms of the property or the assets that fall within the insolvent estate as declared by a competent court. So the Insolvent Estate then gets to be administered in terms of the Insolvency Act of 1936. However, the insolvent lacks capacity to act in respect of assets. We've already said that. The trustee of the sequestrated estate then administers and liquidates it for the benefit of all the insolvent creditors. And since not all the insolvent assets may necessarily fall into the insolvent estate, only his capacity to act in respect of assets falling into the insolvent estate is limited. We are saying that in the process of sequestration, there may be some estates that, there may be some assets that are excluded from the insolvent estate, maybe owing to some other factors. So the insolvent continues then with the capacity to act in respect of the assets that fall outside the insolvent estate, but will not be able to act in respect or in connection with the assets that form part of the insolvent estate. The insolvent also requires the trustee's consent in respect of transactions that may affect the insolvent estate. So because the capacity gets restricted or limited, the insolvent sometimes has to consult with the trustee before undertaking some of these transactions that he may want to undertake. Once more, take a look at our scenarios. We began by looking at these scenarios. Our discussion has dealt with most of the issues that are discussed in these scenarios, and I hope now it has become exactly clear to you what we meant and why we gave you these scenarios in the first place. Now, we have come to the end of our discussion. I'd like you again to reflect on the scenarios that we began with, and remember that the capacity to act in terms of the law of contract is a very essential aspect, because only those with the capacity to act may do so. Only those who possess the capacity to act are competent to conclude valid juristic acts. Capacity to act is not to be confused with legal capacity or civil liability and criminal liability, as we have already stated. Thank you very much for being part of this discussion. Looking forward to sharing again with you in future. Bye-bye.